Hello, my name is Dean Contover, and this is the Current Buzz. Today we have Attorney Dale Tamburro. He's the elder care, estate, probate planning lawyer. He's an attorney. He usually goes to the senior centers in the area. You've probably seen him in Chempsted Senior Center. You've been up there a few times. And we're going to talk about COVID-19 and what to do. And you're sitting home and watching this. I think you should listen up. And we're going to explain what you should do. First of all, I want to ask you this question. What is elder law? Is that something new?
No, no, it's just a redefined definition for people who work with older people, but it separates it a little bit from estate planning, where estate planning is really about drafting documents, where elder law involves family decision-making, getting involved with people more than just drafting documents. So it's a different focus, and it's a better term for what really is necessary when you're talking to seniors.
I see, okay. So they come to you, your office, or they come to you at a senior center and sit down with you? With
COVID, we've gotten creative, so we have the various kinds of ways to meet. I still met with clients via Zoom and by phone last year at this time when everything was shut down. I was able to still talk with people. We could use different phones that you can look at each other's face, but that's not terribly convenient. And now I'm meeting at my office, and I also have a home office now that I use if that's convenient for people. But generally the office is set up that I would have less meetings than I used to have. And we don't charge for consultations, so within reason of time use, we will meet with people. And it's always better to meet face-to-face.
I agree.
And I have gone to people's homes to do it, but I've discovered that doing it at their home isn't as good for the focus that they need to hear what has to be said than it is being in a different place. So it's sort of like having home field advantage. In reverse, you want to be at the lawyer's office if you can, or at the senior center. I've been doing Chelmsford Senior Center for about 6 years now, and up until the pandemic, I was there 9 times a year, 9, 10 times a year.
We have your phone number, so let me read it. And it's I hope I have the right one. Yeah. It's a 617. 489-5919.
Yes, I'm glad you used that one. That's the office.
Yeah, that's the office.
There's someone there 9 to 5, usually 9 to 6 every Monday through Friday.
Yeah. So use that phone number, 617-489-5919, if you have any questions, right?
Sure.
Just say you saw me
Sure.
on
That's
the show,
exactly right. You either came to a webinar, seminar, or saw me on this. Whatever it is, my goal is to educate people and make them feel comfortable.
Okay.
Elder law is a relationship building situation. You really can't just have a 5-minute phone call and tell them what to do. It doesn't work that way.
Okay, let's talk about what to do. Let's talk about the basic thing, wills. You know?
Sure.
Should a person have a will or not have a will?
Everybody should have a will, but the real issue is, what does the will do for you? What doesn't it do for you? And what else do you need other than the will? So going back 50 years, people would say, I've got a will, I don't need anything else. And that's just not true anymore. It hasn't been for a long time.
So what happens if I come to you and I have a will? How long is a will? Is it a standard procedure, or is it whatever I want to add to it?
Oh, if you have a will, there's specific rules that you have to follow to have a will. Witnessing, notarizing, initialing. A will dictates where you want certain things to go when you die. The problem is that some things don't go according to the will. Some things go according to how you own it. Some things go if you have beneficiaries. So the will, for instance, won't affect like a life insurance policy that you name your children as the beneficiary. If your life insurance policy says, I leave, my beneficiary is my daughter, but your will says, I leave my life insurance to my son, the daughter gets it. The will essentially is a safety net for everything else that you don't have another way of saying where it goes. So a will really is the end of your estate plan, if you would. It's the safety valve in case you don't do it other ways. But everybody should have them just because of that.
Okay. Now, some people have wills and trusts.
Correct.
Can you have a will and a trust?
You should have
Can
a
you
will
have-
and a trust, yeah.
And can you have just a trust? Is
You
it-
can.
Yeah, okay.
You can. So what a trust,
explain a trust is.
a trust is a document that allows for you to create it, someone to manage it called the trustee. And in a traditional first trust, if you would, they have you yourself are the creator of the trust. You are also the manager of the trust, the trustee, and you're the lifetime beneficiary of the trust. Now, once you create a trust, there's nothing in it yet. So then you have to get to putting things in the trust. The easiest thing to describe is real estate, because real estate requires a deed that gets recorded at the registry of deeds. So John Smith transfers his house to the John Smith Revocable Trust. You record that document. Now that trust holds John's house. And when John dies, the trust, you read the trust to see what happens. The trust might say, when I die, I leave the house to my 3 children. Then it might say, if any of my children predecease me, their share will go to their kids. So a trust can go beyond just one beneficiary. It can have, I leave it to my 3 children, but that one son of mine who has a fast lane pass to, well, Encore now, the casino. And so I don't want that son getting all of his money all at once. So I will take his share and have it managed by my new trustee, whoever I pick. And that person will manage it according to the terms of the trust. So the trust is like writing a story where you are the author, I'm your backup author. So you tell me what you want, I put it in legalese, and that's what a trust
So,
is.
okay, so I want a trust. I want any money go to my daughter, for example, to pay for any college tuition, all right? But I don't want her to get the bulk of the money till she's 25
There you go.
or 30.
Sure. Sure.
I could do that.
You can say until she's 25, the trustee shall use the money for her benefit in any way they deem appropriate, or you can be specific just for college, or you can say
travel.
for medical emergency, travel, a car within reason that the trustee picks, things like that. And then at 25, she can have half of it. You know, then she gets her first bite at the apple. She takes that money, she learns her lessons, and then there's still the other part of the money left over for her to use. Sure.
Oh, okay.
Sure.
So you could do it that
Sure.
way. All right. So I think we were talking earlier about deeds in regards to be careful about putting the deed in your children's names. Can you put a deed in your 3 children's name, let's say?
So the issue, many people, their biggest asset is their home.
Right.
So when you own your own real estate and you're worrying about what happens if you passed away or you got sick, most people are thinking about avoiding the probate system, which is where the will comes in, or protecting it from the nursing home. And what they're not thinking about is potential tax ramifications. But those are the 3 things you worry about. The other thing you have to worry about is control. Now, some parents don't want to lose control, but if you deed your house to your child, even a child that you completely trust, sorry about that.
I should have told her to shut it off, but yeah, so go ahead.
So you deed your house to your daughter. Your daughter you trust completely. But let's say your daughter gets married and divorced. Let's say your daughter gets into a car accident. Her problems become your problems because you don't own the house anymore. So you never, ever just deed the house to your kid. Now, you can deed the house to the kid, reserving rights in yourself so that you're protected. A life estate deed is one of those ways of doing it.
All right.
So a life estate deed is when you deed the house to your children and you reserve the right to live in it yourself. You reserve the right to the income from it.
Oh, I see.
So what does that do? It avoids probate. It allows for you to live in the house for the rest of your life, regardless of what might happen to your kids' credit issues or marriage or anything like that.
those things happen.
And yes, it does. It does. And I'm not talking like don't trust your kids
Yeah,
here.
right.
I'm saying don't trust what could happen to your kids. You know, car accidents, you get sued. Well, what do you own? Well, I own my father's house. Well, no, I don't really own my father's house. That's my father's house. He just put it in my name. Well, to that insurance company and to that person who got in the car accident with you, they think it's your house and they're going to go
Right.
after it.
Right.
But the life estate also provides nursing home protection. There's a 5-year look back before that is effective. But the life estate deed is a less expensive alternative to an irrevocable trust. An irrevocable trust is another kind of vehicle that you can protect what's in it from creditors and essentially from the nursing home. But with real estate, if all it is real estate, both of those are good choices for different reasons, which is a little too much to elaborate on now.
Okay.
But you don't want to just deed the house to someone, but you can, in a way, do it and get all the other benefits.
Can you deed the house in the sense that, say, upon death? Is that what this more
That's
or
what a
less
life
is?
estate really is. It's
Okay.
saying, let's say that you and I own a piece of real estate
Right.
together. We each own 50% of it
Okay.
right now.
All right.
What a life estate is basically saying is you continue to own it now, and when you die, it goes to her. So it's instead of being 50-50 now, it's now and later. It's just an automatic ownership. So upon your death, it becomes hers, and that's a good thing. That's smooth. Now, if you have multiple kids, if you have 5 children, I don't recommend doing a life estate deed, and I would push you toward that trust. And the reason is you don't want 5 people owning that house all at the same time with equal power. Because if 5 people own the house and 4 want to sell it and 1 doesn't, the one who doesn't wins. You need unanimous agreement and cooperation to sell. So, you know, if you have 15 people and 14 want to sell, the one still wins. But in a trust, you can change that.
I'd like to change the subject in regards to, because of COVID-19. We were talking about this early in regards to health proxies, that if your child turns 18 years old in college and he or she comes down with COVID-19 and you have no say if you don't have a health proxy, and it would be I would suggest that you get a health proxy done as soon as possible.
So a healthcare proxy for me is one of the most important documents you can do, because the bang for your buck for a healthcare proxy is incredible. So in Massachusetts, once you're 18, you have all this privacy protection of medical issues, and therefore no one else can gain information or make decisions for you once you're 18. So this isn't just about elders, this is about anyone who's over 18. So Massachusetts is very strict about it too. They do not allow spouses to make decisions for spouses. It's very clear. It's a statutory law. It's been in place for several years, but it's very easy to fix. You draft a healthcare proxy, and what a healthcare proxy is, it's a document that says, this is the person I want making medical decisions for me if I can't. So it's a substitute process,
Right.
and it only takes effect if it's a doctor signs off saying you are no longer able to do it yourself. So sure, with COVID, it might be more on people's minds. If something happened to me, what happens? You get sick, but you're still of sound mind. Healthcare proxy doesn't kick in yet, but it doesn't really matter whether you're sick or not. Having a healthcare proxy in case it gets worse is just plain.
It's safety.
Yeah, and it's an easy one. It's not terribly
Right.
expensive compared to the benefit. And I've seen the devastation to families when someone's in a hospital room and they can't even talk to the doctors, in essence, and they're telling you to go to court to get a guardianship, which isn't like it's something you can do very quickly, especially during COVID.
Yeah, should a husband and wife get a health care proxy on each other?
Sure. Whoever you want. You know, the
okay.
funny story is the wife will tell me, I don't want him, he'll keep me alive forever. and he says, you know, she says, well, no, he says, I don't want her, she'll kill me off as soon as she can. it's whoever, picking the right person on all of these kind of documents is the most important thing, especially with a healthcare proxy. And you'd be surprised that some people don't pick their spouse, but pick one of their kids or their sister because they think that person will do what they want. Meaning, if your spouse is going to do what they want, not what you want, then they're not the right person. So really, you just have to think hard about the right person. And when I meet with people, I talk to them about that. I explain that with each of the kind of documents that they might do, what the different things they should be thinking about in terms of the person they want.
Right. Let's talk about power of attorney. A lot of people are not aware of this, but power of attorney starts when someone is ill or in a nursing home or whatever, right?
Well, you can have, there's a million different kinds of power of
It
attorneys.
ends when someone's deceased.
Well, that's the important part to know. So a general power of attorney, a general durable power of attorney is a power of attorney that is commonly used when someone wants someone else to do things for them, or they're too sick to do it themselves. So a power of attorney commonly are effective upon execution, unless you put something in it that says this is only effective upon a medical evaluation saying I can't do it. But the important thing that you're saying, and it's really important because people don't understand it, is when the person dies, so does the power in the power of attorney. So you may be acting for this person when they're sick, paying their bills, moving their money around, and suddenly they die and you can't do any of that. This is why the planning part of what you do has to be, here's what I have planned if I become disabled, and this is what I need in place if I was to die. And a power of attorney isn't enough.
Okay. So when someone's deceased, then the will kicks in or the trust?
Yeah, well, if I have a client right now that had investments of a couple $100,000, but the investment accounts name the children as beneficiaries. Does that go to the will? No, it goes to the beneficiaries. Then they have two bank accounts with close to $100,000 in it with only their name on it. So those bank accounts don't know where to go. So that's when the will kicks in. Better would have had both of them, all of them in the trust would have been better. Because remember, the beneficiary clause doesn't deal with certain weird things that can happen.
On the bank account, you could have two people on there, husband
Joint.
and wife, or
You
you
can
could
have
have a child on there.
Joint, or payable on death.
Payable
You
on
can do
death.
a lot of different ways. So each kind of asset, I will tell you, here's the layperson's way of doing things without doing the trust.
Right.
All right, so I'll give you those choices. So let's say that you have 4 children and you put one child on your $100,000 bank account, and you say to that child, make sure you share it with your brothers and sisters. Yeah, well, that's not something I'm going to recommend because when it backfires, then I'm stuck in the middle too.
Right.
So what's the difference is that you put it in the trust, you make that same child the trustee of the trust, and the trust says divide it 4 ways.
I see.
Now, in the first instance, when it's a bank account and payable on death to one child, that child can keep that money. Legally, it's theirs. In the trust, it's not. They have to share it, or they're violating the law.
I see.
Okay?
All right. A gift in regards to federal allows a parent to gift their children
The annual gifts, yeah.
an annual gift of up to $15,000 tax-free.
Right. So what the law is,
Federal law.
the federal law says that you can give $15,000 per donee.
Right.
So if you have 4 kids and 12 grandchildren, you can make 16 gifts of $15,000. If you're married, you can give double that. Now so there's no tax on that, it's a free gift. But what people don't understand is if you give $100,000 to that child, that's also tax-free. It affects your estate tax down the road, but it really doesn't matter as much. I mean, so the gift tax, estate tax is a merger under federal law, and they're changing the laws. But let's say you can make gifts of over $1 million. So when you want to give $25,000, don't panic. You can still do it. What you have to understand is if you're ever trying to qualify for Mass Health, that 5-year rule that I mentioned, that kicks in. This does not exclude this money. There is no exclusion for gifts for Mass Health. So if you make a gift to your child this year for $15,000,
Okay.
you say, fine, I'm not breaking any rules. If you apply for Mass Health within 5 years of when you made that gift, you've got a problem.
So if a person applies, do they have to give back the $15,000?
No, because it's a gift. It's theirs.
I
So
see.
it's the
under the
it's the person making the gift who's got a problem.
Okay. So underneath the federal law, it's okay, but state law, it's questionable. Is that my understanding of it?
Just for the nursing home part of this. So
Oh,
if
okay.
you're trying to apply for Mass Health, which is Medicaid, so Medicaid is a federal term. Mass Health is Massachusetts version.
Right.
The Medicaid program, which is the government program that would pay for a nursing home
Right.
if you couldn't pay for it otherwise, is a combination of federal and state law. So Medicaid and Mass Health merge into one thing. Medicare is a completely different thing. Medicare is basically insurance. It's for health. Has nothing to do with long-term care.
Right. What is probate? Explain to some people who don't understand. And we only have 3 minutes left. So
Probate is a
Yeah.
court.
Is
It's
it
a
a
court,
court?
just like district court, superior court. It's where you go to get divorced, to die, to be disabled. It's a real fun place. It's just a court.
sounds
And
depressing.
the probate process for when you die
Yeah.
is a 1-year process at a minimum.
So if somebody has assets, a car, money in the bank, and they don't have upon death,
Right.
It will
If the
go to
bank account
probate.
doesn't have anybody else
Yes.
it's going to, it just sits there.
what about a car? I mean,
Cars are paying too, because it's a probate asset. There's special rules for transferring between spouses. That's easy. Here's the thing. Take your title to your car, sign the back of it, put it back in the drawer. And when you die, someone find that title, predate it. Predate it from date of death.
Oh, okay. So is it advisable to have two people on the title of a car?
Maybe. It depends on how the insurance works. If there's no difference in how much your insurance costs, then sure.
Oh, okay.
Sure.
All right. Oh, I see. In other words, if they have a bad driving record
Yeah,
or something,
yeah.
it would be a little
Yeah,
higher than,
yeah.
than usual. But to save the car, so would it be tied up? Because if it's in probate, you can't move that car. Is that my understanding?
You can people use the car, the insurance companies recognize that, but if you're gonna file a probate just to get a car, that's a big waste of time and money.
Oh, okay.
You know.
So, in other words, make sure you sign the back of the title. and
I didn't
have
say
your
that.
dad-
Oh, I
okay.
did say that.
I'll say it. I'm not an attorney. Just sign the back of the title and put it away.
The important thing
The
is,
problem is people don't understand that a title is like having a deed to
Yeah.
you've
Yeah.
got to save
Yeah,
that title.
yeah, yeah.
Look for your title.
a lot of people
you
have
know.
lost their title, and
Yeah.
you've got to apply for a new one.
Put it in your important papers. It's a deed.
Important
to your
papers,
car.
that's a good way to end. Important papers, you need that spot for a lot of important papers.
Right.
It includes a lot of other things, but everything we've discussed, those are important papers. You want to also list all what you own, your assets, so that it's not a treasure hunt for your loved ones to try to figure things out if you're sick or you die.
Go down to Staples, get a binder, get some plastic sheets, put all your important papers in there, put them in a binder so you know where the binder is, put it in the drawer or a safe if you have one at home.
And tell someone that it's there. Tell someone else it's there.
It's there.
Yeah.
Or puts a note on it with the deed, the title, etc. Is that right?
Whatever you can do.
Yeah.
Whatever you can do.
Okay. Listen, Dale, thanks for coming. We'll have you back. We could talk for hours and hours.
Yep.
But it's just one of those things. I wanted to talk about homestead, nursing homes,
Sure.
but we'll have to do that some other time when things get a little better.
Webinar next Wednesday, March 24th. Sign up with Chelmsford Senior Center if you're interested. We're talking all about trust.
There you go. Trust it is.